Any other appearance? Any other appearance? It appears the judgment debtors are not in court.
Well, my lord, I called him this morning and informed him about it. He said he had received the message.
Okay. Yes, this matter is for ruling. My ruling is ready, but I discovered that if I deliver the ruling, it may touch on some of the substantial issues that are raised in the main summons for judgment. So in the circumstances, I decided to adjourn the ruling till when we had the judgment summons, and the ruling will be delivered together with the judgment in respect of the judgment summons, so as not to further delay the matter. So in the circumstances, I will adjourn for hearing of the main judgment summons. After hearing, then I will deliver the ruling and judgment on the judgment summons. I hope it is clear for you, counsel.
Yes, my lord, it's very clear. And
because there are certain issues. You know, we are at interlocutory stage now.
Yes, my lord.
And I'm not supposed to touch on the substantial issues that are to be dealt with. But from my ruling, I discovered that some of the issues that are meant for the judgment summons have been touched. So that's why I'm not delivering the ruling now. I will adjourn it till when the judgment summons is fully heard. So we'll take a date for the hearing of the judgment summons. Registrar, can you give us a date? Registrar, give me date. Registrar, I say give me date.
Muted myself. My lord, I'm sorry, I was talking. I didn't have muted myself. My lord, 27th of March.
March 27?
Yes, my lord.
Are you sure
27th of March is convenient, my lord?
No, I'm trying. I don't want to give you a date and the court will not sit on that day, because I know that day is very close to vacation. And also before the vacation, before the Easter vacation, there is another holiday, public holiday. So I don't want a situation whereby the date will fall within the public holiday, so that we won't waste time fixing the case and the case will not come up on that day. Registrar, check if you can have an earlier date for them.
My lord, an earlier date in March?
Yes.
No, my lord, the only earlier dates we have in March are all virtual, which is 2nd and 9th. And that week, the court is not having normal sitting. We are only having virtual sitting. So the normal sitting starts on the 14th. Those dates are all occupied. That 27 was a better date. If we can't make it 27, we'll come back after Easter, my lord. That will be in May 8th.
No, I don't want to. This matter has been on since 2015, and even the claimant is late. So let us not delay it more. Can we get either 15 or 16th of March? Let us accommodate them either 15 or 16th.
As the court pleases, my lord. 15th of March, my lord.
Which of the dates? 16.
My lord, 15th of March. 15.
Okay.
Yes.
My lord, the 15th day of March is convenient by us.
Okay.
You just mentioning programs of community. That person is going to be working for the community.
Counsel, to whom did you issue the judgment summons against?
My lord, to the judgment debtors, Krutek.
Krutek is an artificial person. I hope you know what judgment summons means.
Yes, my lord. And to the registrar of the school.
Are you sure you have done
Yes,
that?
my lord. Yes, my lord.
And you have served, and you have proof of service?
Yes, my lord, we do. We have proof of service.
This is like a quasi-criminal matter. So make sure
Yes, my
you
lord.
serve those who are to appear.
Yes, my lord.
Serve them personally.
They were served personally.
Ensure that they are issued with another hearing notice specifically for them to appear on that date.
Okay,
because
my lord.
we are hearing them on that day. This is a judgment summons. When you issue judgment summons, it means the person against whom you issue it will appear before the court and he will be examined on that day.
Yes, my lord.
So please ensure that they are served personally so that if they are not around, we'll know what to do. I don't want to waste time on this matter. It is taking long.
We thank you, my lord, for your guidance. We're guided. Thank you, my lord.
This matter is for ruling. The ruling of the court is ready. However, considering the fact that delivering the ruling may touch on the substantive issues to be dealt with in the course of the hearing of the judgment summons, this case is hereby adjourned to 15th of March 2023 for hearing of the judgment summons. The ruling will be delivered along with the judgment in respect of the judgment summons. Hearing notices to be issued and served on all the parties summoned to appear before the court.
As a court, please.
We thank my lord for his guidance and we wish my lord the crucial direction ahead.
Thank you.
Thank you,
Call
my
the
lord.
next case.
May we be excused.
Suit number NICN
Yes, you are free to go.
CA06
Thank you, my lord.
2018 between Dennis Onel Utum and 1 Cross River State Institute of Technology and Management, 2 Cross River State Government, 3 the Governor of Cross River State, 4 Attorney General and Commissioner for Justice, Cross River State, 5 Commissioner for Education. My lord, the parties are all absent.
Appearance.
With profound humility to your lordship, my
Yes.
name is D.D. Ujong. I
Yes.
appear for the claimant.
Yes. Yes, any other appearance?
My lord, it appears there is no appearance for the defendants.
I'm seeing counsel, another counsel online. It's not in the matter.
No, it's not in the matter. That is the claimants. That should
No,
be
I'm
the
seeing
claimant.
counsel. I'm seeing counsel dress.
Counsel, okay. The only counsel I see here is Ed, who has just finished.
No, apart from Eno Ede, there is another counsel
Okay.
I'm seeing online.
Oh.
It's all right. We have already recorded parties absent, and I'm seeing Dennis, and they called the names of the parties. The party did not answer, so parties are absent according
As
to
a
the
court, please.
This matter is for judgment. Is for judgment. The judgment will be read shortly. Virtually, the judgment will be read shortly virtually. This is the judgment of the court. The claimant was initially employed by the first defendant as a group administrator with effect from 8th of April 2014 on the Consolidated Tertiary Education Institution salary structure contained this on an annual salary of 535,000 naira after completion of 6 months probationary period and due assessment of his suitability. The claimant's appointment was confirmed by a letter dated 6th day of November 2014 and signed by the rector of the first defendant, Dr. William Fadley. However, following institutional reorganization carried out in 2016, the claimant's appointment was converted from group administrator to assistant chief clerical officer on contenders level 5 step 3 on annual salary of 447,000 naira 747 naira. According to the claimant, the conversion means a demotion to a junior cadre. On the 7th day of August, on the 7th day of August 2017, by the letter dated 4th day of August 2017, written and signed by the registrar of the first defendant, the claimant was unceremoniously dismissed from the employment of the first defendant. According to the claimant, his dismissal did not follow due process as it was done by the registrar of the first defendant, who had no power to do so, as the power to appoint, promote, and discipline junior employees of the first defendant, as the claimant in this case is vested in the rector, who is bound to exercise power on the recommendation of the junior staff appointment and promotion committee. The service of any staff of the first dependent is deemed to be pensionable and qualified service under the Pension Reforms Act or any pension law applicable to Cross River State. The claimant instituted this action against the defendants jointly and separately for 1, a declaration that the purported summary dismissal of the claimant from his employment with the first defendant was in breach of the relevant provisions of the Cross River State Institute of Technology and Management Law 2012, the Institute of Technology and Management who gave Cross River State Staff Handbook, the Cross River State Public Service Rules 2004, and the claimant's constitutional right to fair hearing guaranteed under Section 36 of the Constitution of the Federal Republic of Nigeria as amended, and therefore unconstitutional, unwarranted, illegal, null and void, and of no effect. 2, an order setting aside the letter with reference number REG/DIS/ADM/UDO/O and dated 4th August 2017, issued by Oshin Anthony A., Registrar of the First Defendant, purporting to summarily dismiss the claimant from services of the first defendant for being in breach of claimant's constitutionally guaranteed right to hearing. 3, an order directing the first defendant to forthwith reinstate and restore the claimant to his position of assistant clerical officer in her employ, taking into consideration all promotions and advancement due to him. 4, an order mandating the defendants to forthwith pay the claimant all his salaries, allowances, and other perquisite of his office from the month of August 2017 when he was wrongfully removed from his employment to date. 5, an order directing the first defendant to forthwith remit to Stanbic IBTC pension managers all arrears of claimants' pension deductions and contributions already made on his salary by the first defendant, but not yet remitted to the pension fund administrator. 6. 1,750,000 naira as being cost of litigation of this suit paid by the claimant to his legal practitioner. Upon being served with the originating processes commencing this suit, the defendant entered appearance on the 16th day of March 2018. Apart from the first defendant who filed statement of defense and its accompanying processes on the second day of March 2020, the second to fifth defendants did not bother to file any process in the defense of this case. In the statement of defense filed by the first defendant, it was stated that the rector who supervises the junior staff is not bound by recommendation of the junior staff appointment, promotion, and discipline committee, and that the ultimate power of appointment of staff reside with the council. According to the first defendant, the dismissal letter dated 4th of August 2018, signed by the registrar, was served on the claimant and given to him in error, not having completed consideration of the claimant's alleged gross misconduct by the first defendant counsel, which was yet to be informed of the matter. It was further stated that the first defendant was yet to consider the advice from the legal department as requested, which had been written and sent to the first defendant through the registrar dated 30th day of October 2017, following the claimant's letter of appeal dated 8th day of September 2017. It was also stated that the claimant's letter was not sent to the first defendant counsel, which has statutory duty of staff disciplinary matter on appointment which has statutory duty on staff discipline. The first defendant stated that the allegation of absenteeism is not false, and it is true, as the claimant actually absented himself without lawful excuse for 60 working days between 15th day of October 2016 to 5th day of June 2017. On non-remittance of pensions, deduction, and contribution, the first defendant stated that the non-remittance was not effected because the claimant case of dismissal was still being considered, which first defendant's counsel had not given any decision nor informed of the matter either by the claimant as required nor by the delegated officers of the first defendant as well. The claimant's suit and the claim against the first defendant are not maintainable, nor are they grantable in view of circumstances of this case. The submissions of the claimant. The counsel for the claimant, Victor Kohn Esquire, formulated a single issue for determination, to wit, whether from the totality of the facts and circumstances of this case and the evidence led, the claimant has proved his case to be entitled to relief sought. In arguing the sole issue for determination, counsel submitted that the standard of proof in civil cases is preponderance of evidence and balance of probabilities. Counsel cited the case of Iso Bokon Adelakun to support the submission. Counsel continues submitting that the burden of proof lies or rests on the parties who assert the existence of any state of affairs and who would fail if no evidence is laid by either party. On this submission, reliance was placed on the case of Akande versus Sadisa. Well, counsel, I will skip reading the remaining submissions. When counsel got the hard copy, we'll be able to see the submission. The submission has been fully captured in the body of the judgment. I go straight to the decision of the court. I have carefully considered the processes filed in this suit and the submissions of counsel for the claimant. It is pertinent to note at the onset that the second to fifth defendant in this suit did not deem it fit and necessary to put up a defense to the claimant's claim, despite being represented by counsel. The first defendant who filed statement of defense decided to abandon same when its witness refused to show off in court to testify and adopt the witness statement on oath filed along with the statement of defense. This means that the first defendant has no evidence to support the statement of defense filed before the court. In the circumstances, it means the first defendant has no defense before the court. However, this does not mean that the judgment must be given in favor of the claimant, as failure to file defense does not translate to automatic judgment for the claimant. The law still requires the claimant to meet up with minimal proof for him to be entitled to judgment. By the minimal evidential requirement, a claimant should not expect the court to give judgment in his favor just because the other party did not adduce any evidence before the court. See the case of Lawrence Azenebo versus Bayero University, Kano. See also the case of Ogunyade versus Oshunke. All the citations have been provided. The counsel for the claimant has made heavy weather on discharge of burden of proof on the claimant by asserting that the claimant laid credible and incontrovertible evidence during trial of his case to prove his case, which undeniably entitled him to the grant of relief sought. Counsel for the claimant is also of the view that the first defendant violated the provisions of the law, establishing it by not adhering to the laid down procedure for discipline of staff of the first defendant. He further argued that the documents tendered in evidence which form the conditions of service are violated by the defendant. The claimant by this submission is the claimant by this suit is praying the court for declaration and setting aside purported summary dismissal by the dismissal of the claimant, which was alleged to have been in breach of relevant provisions of Cross River State Institute of Technology and Management Law 2012, the Institute of Technology and Management, who gave Cross River State Staff Handbook, and the Cross River State Public Service Rule 2004, and the claimant constitutional right to fair hearing guaranteed under Section 36 of the Constitution. The claimant is also praying the court to direct the first defendant to forthwith reinstate him and restore him to his position of assistant clerical officer in her employment, taking into consideration all promotions and advancement due to him. There is also a claim for an order mandating the defendant to forthwith pay the claimant all his salaries, allowances, and other perquisite of office from the month of August 2017 when he was wrongfully removed from his employment to date. There is also a claim for remittance of claimant pension deduction and contribution already made on his salary by the defendant, but yet to be remitted to the pension fund administrator. The claimant is also claiming special damages in the sum of 1.750 million as special damages as being cost of this litigation. The reliefs being sought clearly reveal claim for declaration and special damages. The law is tried that for a claimant to be entitled to declaration, he must succeed on the strength of his case, on the strength of the evidence, and not on weakness or admission of the defendant. For a claimant to be granted declaration by the court, he must convince the court. He must convince the court of his entitlement to the declaration in the fullest sense of the word. The claimant will succeed by adducing cogent, credible, and compelling evidence for the claim on payment of salaries and allowances, pension, deductions, and contributions, as well as solicitors' fees, are all claims for special damages, which require to be specifically pleaded and strictly proved for the claimant to be entitled to the special damages. Therefore, the onus cast on the claimant for proving claim for special damages is pretty onerous. See the case of 7-Up Bottling Company PLC versus Augustus, which states that the claim must be particularized and strictly proved, and by NNPC versus Kilipo Nigeria Limited, what appears to be an admission cannot apply to claim for special damages. Thus, a claim for special damages cannot succeed because it is admitted. Claims for special damages are never inferred from the nature of the act complained of. They do not follow in the ordinary course. As in the case of general damages. They are exceptional and so must be claimed specifically. As the claimant will only succeed by adducing cogent and credible and compelling evidence. For the claim on the law strikes that facts that the fact that the defendant did not appear or file defense is not sufficient to be proof of declaration and the monetary claim of special damages by the claimant. Therefore, the Apex Court has, in the case of Gabriel Atibi versus Kabel Metal Nigeria Limited, that stated thus: a claim is circumscribed by a relief's claim. The duty of a plaintiff, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. He may, at the end of the day, obtain all the reliefs claim or less. He never get more, nor does he obtain reliefs not claim. A court is therefore bound to grant only reliefs claim. It cannot grant reliefs not claim. This court will be guided by the decision of the Supreme Court in determining the claims of the claimant before the court. Going by the reliefs 1 and 2, the claimant is praying for declaration that the purported summary dismissal is in breach of the law, is unconstitutional, null and void, and praying for setting aside of the said dismissal from service. The facts about in the pleading and the witness statement of facts in proof is that the claimant was employed by the first defendant as a group administrator, CXBCWD, and the employment of the claimant was confirmed after successful completion of his 6 months probationary period. However, by the letter dated 30th day of September 2016, XBCWK, the claimant's appointment was converted to Assistant Chief Clerical Officer, which is a demotion to him. The claimant stated that a staff in the administration department of the advised him to go and beg the bursar of the first defendant for forgiveness as he was behind the claimant's ordeal, which led to his demotion and postings. According to the claimant, while pondering over the advice, he received a letter of dismissal from the service. We wrote an appeal and for reconsideration and rescission of the decision to dismiss him from service. The claimant stated that prior to his dismissal, he was never suspended, queried, or issued with a warning letter. He was also never charged for misconduct or appeared before disciplinary committee of the first defendant, and that the registrar that signed the letter of dismissal does not have the bias to do so, as disciplinary measures is within the purview of the governing council of the defendant. The first defendant, on its part, stated that the claimant in truth absented himself from duty, and the letter of dismissal was issued to him, to the claimant, in error, and the first defendant has not decided on the case of the claimant. At the risk of repetition, let me say that the first defendant who orchestrated the purported dismissal of the claimant from his service did file statement of defense, but decided to abandon the said defense by failing to have its witness appear before the court to testify in the defense. Therefore, there is no defense before the court since there was no evidence to support the statement of defense. From the pleadings of the claimant, the evidence adduced in this suit, the gross of the claimant is that being an employee whose employment is governed by statute, for any disciplinary action to be taken against him, compliance with the law and conditions of service is mandatory, i.e. the first dependent must, in taking disciplinary action, conform with the law establishing it, and that his dismissal having not been done in line with extant rules and regulations governing the employment is illegal, unconstitutional, null and void, and of no effect whatsoever. The claimant is entitled to reinstatement back to his post and payment of his salaries, allowances from the date of his purported dismissal to date. I quite agree that if a disciplinary action is to be taken pursuant to any statute or law or rule, there must be compliance, there must be strict compliance. There must be strict compliance with the statute or any of them as required before such disciplinary action can properly be based or can properly be taken or justified. See the case of United Bank for Africa versus Ogbo. See also Okocha versus Civil Service Edo State. See also Iderima versus River State Civil Service Commission. See also Federal University of Technology Yola versus Mewuya. All these cases point to the fact that an employer must follow the procedure laid down by law. Where such a procedure is violated, an employee's order of dismissal would be inoperative and void. In law, all that the employer needs to establish to justify his action in this dismissal of or termination of appointment of an employee on ground of misconduct is to show that the allegation was disclosed to the employee and was accorded fair hearing, thus fulfilling the requirement of national justice, and that the disciplinary panel followed the laid down procedure, if any, or that the employee accepted the act after investigation. See Olatu Bosum versus NISA Council. See also University of Calabar versus ASEAN. See also Yusuf versus UBN. See also FUT Yola versus Maiwea Sufra. From XBCWD, the letter of employment, the claimant was employed as group administrator. However, in September 2016, the dependent opted for an institutional reorganization of the first dependent, which resulted in conversion, upgrading, downgrading, and resignation and posting of staff of the first dependent. Following the institutional reorganization, the claimant was affected. Therefore, by letter dated 30th day of September 2016, which is Exhibit CWK before the court, the claimant was informed of his posting and conversion to the General Studies Department as Assistant Clerical Officer on Quantis Level 5, Step 3 on salary of 447,747 Naira per annum and to assist per annum. The claimant has not challenged the action of the first defendant in converting his appointment from a group administrator to that of an assistant chief clerical officer. Therefore, the claimant wholeheartedly accepted the said conversion or downgrading or demotion of his demotion to non-administrative post. It is clear from the pleading, witness statement on oath, and the submission of counsel that which claimant is heavily relying on. It is clear from the pleading, witness statement on oath, and submissions of counsel that the claimant is heavily relying on his letter of employment, Exhibit CWD, Cross River State Institute of Technology Law 2012, the Staff Handbook of First Dependent, and the Cross River State Public Service Rules 2004, ensuring that the letter of dismissal is illegal, null, and void for having been issued in violation of extant laws and the condition of service as encapsulated in the Staff Handbook Exhibit CWU. A careful perusal of Exhibit CWD letter of appointment as group administrator will show that the disciplinary rules applicable to the claimant as a group administrator is as contained in the non-contractual employee handbook Exhibit CWU. However, with the conversion of employment of the claimant to the Assistant Chief Clerical Officer, the procedure for discipline applicable to him is as contained in Section 23 of the Cross River State Institute of Technology and Management Law 2012, which with this finding, the provision of Section 22 of the Cross River State Institute of Technology Law 2012, which deals with removal of a member of academic, administrative, or technical staff of the first dependent, is not applicable to the claimant case. Likewise, the claimant not being an employee of Cross River State Civil Service, the provisions of civil service, the provisions of Public Service Rules 2004 are not applicable to the claimant, since he was not employed by the Civil Service Commission or Civil Service Commission of the Cross River State. In view of the foregoing, the relevant provisions of the law governing the procedure for removal of junior members of staff of the first dependent is as contained in Section Section 23 of the Cross River State Institute of Technology and Management Law 2012. The section provides, I quote, if any staff is accused of misconduct or inefficiency, the rector may suspend him for not more than 3 months, and forthwith shall direct the junior staff appointment and promotion committee to A, to consider the case, and B, to make a recommendation as to the appropriate action to be taken by the rector. In all the cases under this section, the officer shall be informed of the charge against him and shall be given reasonable opportunity to defend himself. 3, the rector may, after considering the recommendations made pursuant to subsection 1B of this section, exonerate, dismiss, terminate, retire, or downgrade the officer concerned as may be appropriate. 4, any person aggrieved by the rector's decision under subsection 1 of this section may, within a period of 21 days from the date of the letter communicating the decision to him, address a petition to the council to consider his case, and the council decision thereon shall be final. 5, in any case of gross misconduct on the part of a junior staff, the rector shall forthwith suspend him and thereafter refer the matter to junior staff appointment and promotion committee to be dealt with according to the foregoing provisions of this section. It is clear from the provisions of Section 23 of the Cross River State Institute of Technology and Management Law 2012 that this law has made ample provisions on how member of staff of the first dependent in the junior cadre case can be dealt with, like as the claimant when he has committed any infractions requiring disciplinary action to be taken against him for the default. The claimant whose employment is that invested with statutory labor must be dealt with in accordance with the law. This is because employment and removal of employee has been provided in the law establishing the first dependent. See Federal Medical Center versus Ido Ekiti. The Supreme Court has stated that the conditions of service which will give statutory labor to a contract of service cannot be a matter of reference. They must be conditions which expressly set out by statute. See Idoniboy Obu versus NNPC. See Ogebe versus Benedio. See Ujam versus Institute of Management Technology. See Azenebo versus Bayero University, Kano Sufra. In the case at hand, the claimant was dismissed from service by the first dependent as per Exhibit CWA for absenteeism. However, in the pleading and evidence before the court, the claimant has stated that he was never queried or suspended or given opportunity to defend himself before his dismissal from service. He also stated that he was not dismissed by the appropriate person, as the person who signed the letter of dismissal is one Oshim Anthony A., the registrar of the first dependent, who has no jurisdiction to do so. The law is tried, a public servant, a public officer against whom an allegation of gross misconduct is laid cannot be removed without being heard. See FUT Yola versus Mewia, see NEPA versus Ango. An employee is also entitled to formal notice of the allegation against him given opportunity to defend himself. See Inze versus MPA, see Ayetan versus Nigerian Institute for Oil Palms Research. See also Adeni versus Governing Council, Yaba College of Technology. The principles of law enunciated in the above cases aptly captured by the provisions of Section 23 of the Cross River State Institute of Technology law. As per accusation of misconduct, a junior staff is entitled to know the accusation against him, and the allegation must be referred to the junior staff appointment, promotion, and discipline committee to investigate and make a recommendation to the rector, who is invested with power to either exonerate, dismiss, or downgrade the officer. In the case at hand, the claimant was dismissed from service by the registrar of the first dependent without the allegation of absenteeism made known to him and given opportunity to defend himself. The first dependent failure to religiously follow the provisions of Section 23 of the Cross River State Institute of Management Technology Law 2012 has rendered the dismissal of the claimant illegal, unconstitutional, null and void, and of no effect whatsoever. And the claimant is entitled to have Exhibit CWA set aside, and I so do set it aside. It is pertinent to point out here that apart from the letter of dismissal signed by the person not having the bias to dismiss the claimant, the dismissal of the claimant was on the directives of the management of the first dependent. The law does not recognize that body as the appropriate authority to dismiss an officer of the caliber of the claimant. The provisions of Section 23 is very clear and unambiguous. Did not recognize registrar or the management of first dependent as the person to take disciplinary action against the claimant. It also did not recognize the management as appropriate authority for dismissal of employee. The law recognizes the rector as the appropriate authority to dismiss a junior staff like the claimant from this service, from his service. The claimant the claimant having not been dismissed by the rector as required by the law, the dismissal cannot stand.
As the court pleases.
Having found the dismissal of the claimant to be null and void, he is entitled to reinstatement back to his job. I hereby ordered immediate reinstatement of the claimant. On the claim for payment of salaries, allowances, and other perquisite of office from August 2017 to date, the law is that where an employee's service is protected by statute and his employment is wrongfully terminated, he would be entitled to reinstatement of his office, and in addition, damages representing salaries during the period of his purported dismissal. See the case of Shitabe versus the Public Service Commission. See also Olanian versus University of Lagos. See also Udo versus Cross River State Newspaper Corporation. See also MBTE versus Anyao. See also CBN versus Igulo. Applying the principle of law enunciated in the above cases, to the present case, the claimant is entitled to payment of his salaries from the date of his dismissal, that is 7th day of August 2017 to date, and subsequently until when his employment is properly determined. From the date of his dismissal of the claimant to end of January 23 is a period of 5 years and 5.5 years. The claimant has stated in his pleadings and evidence that his salary per annum to be 477,747 naira per annum. If this amount is multiplied by the 5.5 years, the salaries of claimant will be the claimant will be entitled to will be the sum of 2,627,608 naira 5 kobo. 5 kobo being his salaries from the date of his dismissal to end of January 2023. On pension deduction and contribution, it is a case of the claimant that the first dependent remitted pension deductions and contribution up to 31st day of December 2016, but failed to remit deductions and contributions for the months of January to July 2017, totaling the sum of 54,999 naira 74 kobo. There is no any evidence to controvert the claimant assertion on pension deduction and contributions. The claimant has proved his case on pension. Same is hereby granted. The first dependent is hereby ordered to pay the sum of 54,999,074 naira to the claimant's pension savings account with Stanbic IBTC Pension Fund Administrator. On the claim for on the claim for the sum of 1,750,000 as special damages as cost of litigation, this claim is not part of the course of action in this matter. Therefore, it is not appropriate for this court to grant it. In the circumstances, the claimant is not entitled to the sum claim as cost of litigation. From all I have been saying above, the claimant has substantially proved entitlement to most of the reliefs being sought. For avoidance of doubt, the order of the court is as follows. 1. The dismissal of the claimant from service of the first dependent is hereby declared unlawful, illegal, unconstitutional, null and void, and of no effect whatsoever, for having been done in contravention of the law and the breach of doctrine of natural justice. The letter of dismissal dated 4th day of August 2017, tendered in evidence and admitted in evidence as Exhibit CWA, is hereby set aside for having been issued without bias. 2. The dependent is hereby ordered to immediately reinstate the claimant back to his job with all his entitlement rights and privileges. 3. The claimant is entitled to payment of his salaries from the date of his dismissal to the date of to date and subsequently until proper determination of his employment. The first dependent is hereby ordered to pay the claimant the sum of 2,627,608 naira 5 kobo being salaries from the date of his dismissal to 31st day of January 2023. 5. The first dependent is hereby ordered to pay the sum of 54,999 naira 74 kobo into the claimant's pension savings account with Stanbic IBTC Pension Fund Administrator as being deductions and contributions from January to July. The claimant is entitled to cost assessed at the sum of 500,000 naira. The dependent is hereby ordered to pay the claimant the said sum of 500,000 naira cost. judgment is entered accordingly.
As the court pleases. My Lord, for the claimants, we are very grateful for this erudite judgment.
Yes.
We pray that God should continue to give you the strength to show scholarship in what you do. We are very grateful once again.
Amen. Amen. Yes.
Yes, my Lord, we are very
Registrar,
grateful.
Yes, you
My
are
Lord, we are
welcome.
very grateful.
No, my Lord. That was your
Okay. So thank you, Counsel.
that we have on the list.
You said?
That matter on the list.
Okay. Thank you very much, Counsel.
Thank you very much,
You
my
can-
Lord.
Administrator, you can discontinue with the sitting.
As the court pleases.
Thank you, my lord.
Thank you.